attendees who have joined us today. We have several hundred participants joining us for today's webinar on how to insure against COVID-19. One of the biggest topics that condominium and homeowners associations are dealing with today. For those who I have not met previously, my name is David Cohen. I serve as Executive Vice President at AKAM. For those who are not familiar with AKAM, we are the premier residential management provider here in South Florida throughout the Tri-County market. We service over 50,000 units and have numerous clients very similar, I'm sure, to the properties that you all participate within. Without further ado, we're going to go ahead and just get started with some introductions. I'm going to turn it over to Joe Knopp from Brown & Brown Insurance.
Thank you, David. Joe Knopp with Brown & Brown Insurance. I'm a Senior Vice President with Brown & Brown. We are the largest insurance broker in the state of Florida, publicly traded, 5th largest in the world. I've been with Brown & Brown for 24 years. Our team of condominium experts represent the largest book of business in our entire company, and we look forward to this webinar. Thank you.
Excellent. And without further ado, I want to introduce JP from Super Restoration.
Thanks, David. Good morning, everybody. JP with Super Restoration. Been with the company for 14 years. I'm a national account manager, and right now we are the second largest company in the world due to some mergers and acquisitions, and I appreciate the opportunity to be here today.
Excellent. Jackie, can you hear me okay now? Just want to make sure that the quality is okay. Yeah. Jackie wrote in that it was a little
you're a little bit distorted, like Jackie said. You cut in and out a little bit.
Okay, my apologies. Michael Bender, also from Kaye Bender Rembaum Legal Firm.
Thank you, and I want to thank you. First of all, I want to thank everybody for doing your short intros and giving me your additional time. So, I want to thank AKAM and Brown & Brown for co-hosting, inviting me to be a panelist. I look forward to working with all of you on this great panel. Good afternoon to all the attendees. You're in for a treat, I think. Kaye Bender Rembaum, for those who don't know, we are a law firm that specializes in the representation of Florida community associations. We represent over 1,200 associations with 19 lawyers, 8 of whom are board-certified experts in the field of condominium and planned development law. We do pride ourselves on combining this experience in community association law with excellent customer service, which is, I think, something we all here believe is very important. We have offices in Broward County, Palm Beach County, Hillsborough County, and we make by appointment in Miami-Dade County. We regularly publish 2 news publications, Legal Morsels, written by Robert Kaye, focusing on new court cases and legislation relevant to community associations, and Jeff Rembaum publishes Rembaum's Association Roundup, community association news you can use, with also focusing on court cases, legislation, other matters that affect board members, managers, and members of our community associations. Robert Kaye and Peter Mullengard are 2 attorneys in the firm, host radio shows. Robert's is monthly, Peter's is weekly. We also provide many webinars on a variety of association subjects of interest. And lastly, we're very active in legislation on the legislative front for community associations. Sean Brown and Allison Hertz are attorneys that are actively involved with the Florida Bar's Condominium and Planned Development Committee, and I actually serve as the chair of the Florida Legislative Alliance, the legislative arm of CAI. Look forward to all that information is at kbrlegal.com, and look forward to working with everyone today on this webinar. Thanks again.
Excellent. Thank you, Michael. Before I turn it over to John Moeller, my co-host over from Brown & Brown, I just want to reiterate and thank all the panelists this afternoon, including Joe Knopp from Brown & Brown, John Moeller from Brown & Brown, JP from Super Restoration, and of course, Michael Bender from Kaye Bender Rembaum, and all of my colleagues here at AKAM. I will turn it over now to John to begin the webinar.
All right, thank you, David, and thank you for everybody for joining. Hope everybody's staying safe out there. My first question is going to go to Joe Knopp. In the whole wake of these current events that we're having right now with the coronavirus, how do you see this and some of the past events that we've had in the world and in the United States to affect the insurance industry, not only coverages, but on the cost?
Okay, good question, John. Well, first of all, the recent 2020 issue with COVID didn't help the marketplace, certainly. The market actually started changing about 18 months ago. we were in a soft market, meaning premiums going down, more programs than ever being available from 2010 to 2019. And we entered the hard market like about 18 months ago. And what that means is that reinsurance started to dry up. Reinsurance is insurance that insurance carriers buy on themselves, okay? And it's to be able to generate funds to pay claims and to stay solvent and to stay rated. So the only way to raise more reinsurance funds and replenish the pot is to raise rates. And we just wrapped up the costliest decade on record in that time period from 2010 to 2019, over $260 billion in claims. And we are connected worldwide. So it's not just hurricanes in South Florida, it's world events. You got to think about floods, fires in California, anything catastrophic. So the well dried up. So that's why the rates started going up. And certainly this new situation with COVID, and it's just starting to brew up legally, is not helping the situation.
Thank you, Joe.
Mm-hmm.
That's great. Actually, that brings up a good point from the COVID side, from an insurance perspective. From a legal side of things, Michael, what is the board's legal liability for decisions made throughout and during the COVID crisis?
Okay, that's a good question too, David. The issue of legal liability, and Joe just touched upon it, actually, that last kind of throw-in comment, which I think, Joe, is a really, you could probably talk a long time about that, is really we're just the exposure, or is there exposure to board members and management team with regard to decisions made during the COVID crisis? And the answer really, it's an unknown. One thing I want to point out to everybody listening, and we talk about this all the time, this pandemic is a case of first impression. There might have been, apparently there was something about 10 years ago that I certainly lived through, but I have no, I don't remember nearly the swine flu like we're talking about COVID-19. This is a case of first impression. And so we in all of our industries, we're all dealing with this, and we're working our way through to see the best way we can function in conjunction with the state order, the county orders, municipality orders. And so legal liability for decisions made during the COVID crisis, I don't, unless a board is overtly ignoring guidance that's being provided by professionals, that being the health professionals, that being their management professionals, that being their legal professionals, that being their insurance team, unless they're overtly ignoring, they're not going to certainly have personal liability. As far as whether the association will have exposure to liability, that's a question that we'll get into a little bit further. I can do it now, or we can talk about it a little bit further, but that's going to depend on whether we're talking about exposure for keeping amenities closed, keeping people out, versus exposure for opening amenities and allowing people in. Those are two different sides of the coin.
When you talk about exposure, over to Joe again, are you familiar with any types of exposures that a board or an association may have if and when a lawsuit is brought about for someone either who gets sick at the property or accuses the association of any type of negligence? Is there any type of exposure that the board may have outside of maybe standard D&O coverages?
Are you directing that question to me or to Mike?
I'm curious from an insurance perspective, if you come across this at all, what your thoughts are.
Sure. Whether it's a board member or an individual or the association, the key is to make sure that you have representation, okay? So if the directors and officers liability or standard policies decline because there's some specific exclusions in most of the policies, the key is to have defense coverage. And the vehicle that we have been adding and using for our clients is called prepaid legal. There's several products out there that the association can buy as an extra layer of protection so that they have defense, covered in the event that there's a lawsuit that comes up and they try to blame the association or an individual.
Got it.
Yeah. I can, David, if I want to quickly piggyback off that, that actually, I guess, addresses the question. You have the two forms of liability. If there's the D&O, as Joe mentioned, the directors and officers, and then you have your liability coverage. And Joe and John can definitely address this if I say anything incorrect. But the D&O coverage, when someone makes a claim regarding, hey, you exposed me to COVID, the directors and officers is going to be excluded because that's just not part of that type of coverage.
Correct.
Correct?
Correct.
Yes.
Right. Okay. And so so that's out the door. Then it's like, okay, we have a liability policy. And as Joe just indicated, and that's the kind of policy that most likely has exclusions in place, which is now going to eliminate your liability. And therefore, if you're left with no coverage, that's to Joe's point. This legal defense or gap coverage is what board members should be getting with their insurance agents. Guys, I can't preach this enough. If you're on this webinar and you've not yet met with your agent, schedule that today. Sit down with your agents, talk about what coverages you have, what coverages you don't have, what exclusions are there, what endorsements don't you have that you might be able to add. Get educated on what's there and what's not there, and whether you have legal defense, this gap coverage or not, and its cost effectiveness, because it is something good to have if those things are exposed. Now that's if someone brings a claim that you've exposed them to COVID. The flip side of that is if you're keeping amenities closed or restricting, and someone's claiming you're breaching your fiduciary duty by not allowing me to use these amenities, that's a different type of claim. And in my experience, that's a claim that will most likely be covered by your D&O policy. Joe?
Correct. And let me add one more thing. These prepaid legal policies are extremely reasonable now, meaning they're affordable. Typically, they're under $5,000 a year. They provide unlimited defense costs with no deductible. But as we maneuver through this time period in our lives, and this becomes more and more relevant, and hopefully it's not going to turn into a disaster, but experience tells us that there's going to be some lawsuits and things like that. Get in while the premiums and the rates are good, because that'll help you along going forward. It's very, very reasonable.
Right.
But
it's important though, and Joe, it's important for us to also point out with those coverages, the gap coverage or legal defense, it is fees only. And I see that, Marianne, thank you for, I was going to point that out, but Marianne, you beat me to it. But yes, it's fees only. It doesn't cover costs. If there are costs involved, depositions, those types of things, and it covers absolutely no settlement or judgment. It's just fees. So that is a limitation, but it's certainly better than nothing.
It's unlimited defense cost with no indemnity, correct?
Right. And I believe no deductible.
No deductible.
So those are the good things, but it is limited, and you do not have any choice of attorney. I can tell you one story that I know of, because I had one story where I got a community who did get assigned an attorney, and the attorney had no idea what they were doing. They were so disappointed they ended up going and hiring their own co-counsel and paying out of pocket.
It's with any insurance company, it's the person you get. There's a panel of attorneys, so you have the choice of maybe going to a different attorney that's on their panel.
Okay.
Yeah. There's not just one attorney. Yeah.
Michael, piggybacking on this topic and actually taking it, I guess, one step earlier from a potential liability, can a property or a board demand or require homeowners that are maybe returning from outside of the U.S. or another country to quarantine? Are they required? Can they require a resident or a homeowner to quarantine for a specific period of time?
There was a period of time where there was an order in place by the Governor DeSantis that required anyone coming from hotspots, New York, New Jersey, Connecticut, the Tri-County area or some other areas, that you were required to quarantine for 14 days once arriving. And if you didn't, then the association's responsibility there would be to report you. I'll touch on that a little bit further. That order has been lifted. In fact, as many might know, that order got reversed. Now, anybody from Florida going up to the Tri-County area is supposed to quarantine because we were become the new hotspot. So as far as I'm aware, there's no order in place that mandates that people coming from anywhere else quarantine for 14 days. That said, even if there were, when you say can they force it, the association is not going to be able to enforce it by doing anything other than reporting. You would contact, when it was in place, what we would encourage is if people are not following these requirements, in the same way if someone tests positive and they're supposed to self-quarantine for up to 10 to 14 days, depending on what CDC guidelines are following now, you're not going to you can't chain lock them into their unit. You can't force them in there. You can report them to local authorities. You can report them to the Department of Health and ask for guidance from those departments as to what can or cannot be done, what they can do to assist in making sure this is okay. Some of the orders did hold people responsible if they had positive tests or they weren't quarantining when they were supposed to, that they could face monetary penalties or civil action. It's sort of in flux right now.
Thanks, Michael. I want to direct something actually over to JP. When you talk about protocols with regards to cleaning specific chemicals, what are you seeing in the marketplace with regards to those specific protocols?
Well, right now there's a 3-step process. It's really cleaning, disinfecting, and protecting. So clean, disinfect, and protect. Those are the guidelines that we're following. Reference chemicals, you want to try to stick to plant-based chemicals. That's what we're doing. There's over 20 plus approved chemicals by the CDC, but the plant-based ones are the ones that produce less odor and are less health hazardous. And you can go back into the facility within 15 minutes to an hour versus to 4, 6, or 8 hours with these other type of chemicals. So you definitely want to make sure that the vendor that you're hiring is using some type of plant-based chemical approved by the CDC. Currently, 2 that come to my mind are one called BioEsk and Benefect. And those are the ones that we actually carry because we can kind of get those areas streamlined much quicker. If it's a common area, if it's a gym, if it's a corridor area that we're servicing, it doesn't have to be out of service for 4, 6, or 8 hours, especially the lobbies as well where there's high traffic.
That's excellent.
To piggyback on that, JP, something that we're hearing a lot of from a management perspective is, are there companies out there that can perform like a cursory overview of cleaning protocols from a third-party perspective? Are you getting requests from any of your clients to come in and kind of do a review of some of the cleaning protocols from a potential liability standpoint, or is that not something you're seeing?
No, that's an excellent question, Dave. And yes, I'm actually seeing more of that on the commercial side versus the condo side, where they're hiring third-party hygienists to actually write protocols, right? And obviously there's going to be a fee for that, right? But yes, from a liability standpoint, it's good. The more paper you have, the more documentation you have from different professionals, the more you're going to protect yourself. So yes, if you want to encounter that expense, I would definitely recommend it, because I'm always a big believer in, 4 eyes is better than 2 and 2 brains are better than 1. So yes, they are doing it. And I believe some of these assessors are charging anywhere from about $1,000 to $2,500, depending on the square footage of the job that you're going to disinfect.
JP, Dave, if I may, JP, everything you just said, I was really great for me to hear as well. But I do want to piggyback off what JP just said at the end. I think it's a great idea, but along the lines of what I said earlier, if you're going to get that kind of advice, and this is the proper way to do it, in some instances, you need to know what if you choose not to follow it, is that going to have any negative context? So definitely communicate with your legal counsel with regard to this advice you're getting, and then the steps you're going to be taking as to what type of exposure, if any, it will entail. And the second part is, and this is something that our insurance team will support for sure, is when you are under the county orders, even though we're into phase 2 in all counties, those orders regarding your fitness centers, your pools, your amenities, they all remain in place as far as your sanitizing, your cleaning, your restrictions of attendance. But in particular, to JP's point with the cleaning, make sure you're doing it in accordance with the orders, and make sure you're documenting that you're doing it. So if someone down the road does bring a claim, which in my opinion should be considered frivolous, but it's all fact-based. But if someone does bring a claim, you have the documentation to support the fact to your carrier, hey, look, we have been following everything along here. We've been doing everything that we're supposed to be doing, so that your coverage, to the extent it's there, is in place. And if it's not, you at least have a defense to anyone's allegation that you were negligent in opening up and not following proper protocol.
And real quick, Mike, that's an excellent point, because I get this question all the time where I have building management or board of directors, they say, hey, what are the best chemicals to use? We're going to buy the materials ourselves and we're going to do it in-house. And that word in-house can be very dangerous because of the documentation purposes, because of the necessary procedures and industry standards to follow. So you're 100% correct on that. Not to say you cannot do things in-house. However, if you are, document and take pictures of everything you do, because everybody knows we live in a paper pushing world.
And do it right if you're doing it in-house.
100. If not, you can call JP.
Yes.
JP, I think you mentioned specific products earlier on in this topic. Can you repeat what those products were?
Yeah, BioEsk and Benefect. Those are the 2 products, and they're all based off water-based solutions. They're like tablets that you put in and you mix them with water, and that's how the process starts. And we use a thermal fogging mist spray to disinfect these areas with these products.
Excellent. And Tricia, to your point, yes, this webinar is being recorded and it will be distributed. For anyone who is not able to attend, they'll be able to view the recording.
And we'll put a link up on our website. I'm sure everybody here will.
Absolutely. The more people that can view it, the better. These are important topics in the time that we're living in. Joe and John, going back to the insurance side of things, what are you seeing from your clients with regards to funding those potential insurance increases in the market that we're living in?
Okay. Well, first of all, a very important component to this whole process is to be very close in touch with your broker. Make sure you're properly doing your budget because the market's changing so fast, and do the best you can with the budget. You may even want to include an extra line item for deductibles. If you're a building that has a lot of water damage deductibles and you have a $5,000 or $10,000 or $25,000 deductible, you want to put that in your budget because that way they can, charge the association and it'll be in their maintenance. In the event of a disaster, there's a couple ways for the associations to get money. Obviously, typically when we have a hurricane, especially, they never hit the deductible usually, and you have to special assess to bring the building back to its original form. So more than ever, it's important to educate the unit owner on their responsibility according to the 718 statute as to carrying coverage, because in Florida, if they cover an have an HO6 policy, including windstorm, when we go to do a special assessment, their homeowner's policy will respond and actually help pay for that assessment. That's like probably the healthiest way to have a building. And what we do at Brown & Brown is we do what we call a community meeting once or twice a year. We remind the residents, because a lot of people move to Florida, they figured they get their certificate from the office, they're good to go at their bank, they don't need to buy insurance. There's so many more things that go into it, and this is key because it would make the building whole. And what we do for our clients is we take their deductible and we divide it into the number of units to show the total exposure. Most buildings are $3,000 to maybe $7,000 a unit, and most homeowners policies automatically come with a $2,000 loss assessment limit built in, and you can increase it to $5,000 or $10,000. So the best ways to prepare for this, and the rates going up, is budget, line of credit, and making sure you educate your unit owners to have insurance.
No, that's great information, especially because we are in budget season. From a management perspective, all of our clients are obviously starting their budget prep or have already completed it. So including those additional line items for potential deductibles or increases in insurance costs, I think is extremely important. Michael, when it comes to testing, a big topic of discussion, especially in self-managed communities, what we're hearing from a management regard is boards are inquiring whether they can require an employee coming back to the association to test positive or negative for COVID prior to returning back to their job functions. And again, like I said, it's even more prevalent in self-managed environments where the association is employing that personnel directly. What are you seeing from a legal side of things with that regard?
Well, David, what I'd like to do is I'd like to first piggyback off the funding question with the deductibles, if I've already answered that, because I do want to add there's a few, I think, very important legal aspects to that. So with the funding of your insurance deductible or insurance increases, and the line of credit being an option. And I think one of the things that you hear a lot about or has been, I'm sure Joe and John have talked about this with a lot of their clients too, is going out and getting a line of credit, having an emergency line of credit lined up to address your insurance issues, whether it be for an insurance deductible or whether it be to address the damage that is going to be required to be fixed before your policy coverages will kick in. And I just want to remind everyone, if you're considering a line of credit, board members, managers, if your boards are considering a line of credit, your first step would be to communicate with your banks and get what's called a letter of commitment or some version of that. That's when you want to reach out to your attorney, the association's attorney. Get them a letter of commitment that the board is considering, or board members that you're considering. Get it over to counsel who understands these practice, because we want to review that. We want to make sure the collateral that's being considered is limited to what the collateral should be limited to. It should be nothing more than your regular assessments, not excluding your reserves, and any special assessment that you're considering to adopt, either to repay that line of credit or to address the project for which you're taking a line of credit. It should not be on any other special assessment. It should not include your reserves. It should not include any insurance recovery that you get should be very limited in scope. And most banks that I work with who are familiar with lending to community associations are aware of that, but you need to address it in your commitment letter. 1B is you also need to know, do you need a membership vote to approve borrowing? Boards can pass a special assessment for necessary maintenance items regardless of whether your governing documents require a membership vote. The law says that. But if your documents require that you need a vote of the membership to approve borrowing of funds, then you need that membership vote. And knowing that up front, that will allow you to set your parameters. You'll know it's a 14-day minimum notice for a membership meeting to get a vote out. So get with your attorney up front when you're thinking of borrowing. Second point is with regard to budget considerations, in addition to your insurance deductibles, I just want to point out two quick things. Unfortunately, even though we haven't seen a lot of rising collections overall, there has been some uptick, at least in our offices, and we don't know where it's going to hit come January. So consider your bad debt line item in your budgets. I know this is what your management team will work with. And something that I've talked about before is, do you need to increase your maintenance fees for COVID-related cleaning? You know, to bring JP and his guys in to do more cleaning, or increase your budget for cleaning materials, or with the orders that are in place requiring monitoring. If you want to be able to fully open certain amenities and it requires certain monitoring, you might consider, and this is where you get with your management team and talk about, hey, if we're going to add monitoring, which we wouldn't otherwise have, what would the additional fees for that be? And maybe consider budgeting for that so that you can better open your amenities come 2021. So I just wanted to put that on the table. You guys may want to comment on that after, but that is something to think about with your budgets. With regard to your question, to answer your question, it's real quick. These are CDC guidelines. And once an employee tests positive for COVID-19, they're supposed to quarantine for 10 days from the date of testing, retest 5 days after the first test to ensure a negative result. Okay? So that's the answer with regard to, if you have someone who's coming back. If they've had a positive test, minimum 10 days, and they have to retest 5 days after the first test and ensure negative. And until they can show you a negative test, I would say then you're not having them back. So I don't know if you want to talk more about the budget part, because I know that's in your wheelhouse.
Well, absolutely. And actually, there's a question that just came in, which I think is an important aspect of what you just mentioned.
Sure.
To boards passing a special assessment and what the documents may say regarding a membership vote.
Okay. What it's not, Wendy, it's Florida law, and it's not statutory, it's case law. It's basically what it is if it's a necessary maintenance item versus an alteration or improvement. If there's necessary maintenance, as board members, you have not only the right, but the obligation to maintain your common element, common areas, whether you're a condo, HOA, club, you have an obligation. So what Florida case law has set forth very clearly is that the boards have the right to go ahead and address this necessary maintenance and fund it by way of assessments, even if the documents, like if your document said, hey, if you want to do a special assessment for more than $1,000 a unit, you need a majority of the members to approve it. If that assessment is over $1,000, but it's because you have to replace the roof, which is a necessary maintenance, then the board has the authority to go ahead and do that special assessment without the vote of the membership. And what you do is, if you have a situation that comes up and you're not sure, go to experienced counsel, ask for an opinion in writing that the board and management can rely upon to move forward with this. So that's what I mean by being the authority to adopt a special assessment. It's Florida case law that supports it, but it's necessary maintenance. So just an example, if you have a shingle roof and you want to replace that roof with barrel tile, just to simplify, the shingle to shingle would be necessary maintenance. The roof replacement is necessary maintenance. But going from shingle to barrel tile, that could be considered an alteration that might require a vote. So there's some so these are fact-specific, case-by-case approaches. So and we should have said in the beginning of this, all of us are presenting, guys, this is informational purposes. We're not offering legal advice or insurance advice. And JP is giving guidance. We are, this is, if you need actual opinions from us, you need to obviously contact us and we can discuss. But this is general information only. I hope that answers your question, Wendy.
Yeah, and that's appropriate. And I just want to reiterate that is that for all the board members that are in attendance, please make sure that you discuss this on a one-on-one basis, not just with your insurance agent regarding your renewals, deductibles, and premiums, but also your insurance counsel and of course your management teams. And as Michael just said, if any of us on the line can be of a resource or support to you, we're happy to connect offline. Going back to considerations for a board, and this is really for the whole group, a lot of communities are still in the planning phases for reopening either some or all of their amenities. What are some considerations that the board should be discussing when deciding whether to open up amenities or not?
I'm sorry, Dave, was that to me?
It's really for the whole group. I guess maybe JP, you can jump in from a cleaning perspective with regards to, what boards should consider when opening up, additional amenities.
Well, honestly, Dave, it's really up to them how they want to do it and when they want to do it. I mean, from a vendor perspective, once we're in there to service any type of area, whether it's an amenity or not, our process, once we're done, like I said, depending on the chemical we're using, they can come in 15 to 30 minutes after and go from there. However, what the strategic part of this is, we're trying to do this at nighttime, right? When people are sleeping, right? So we don't kind of bother the residents, or we can do it early morning, right? Because people are going to be walking in the hallways, using the amenities and things of that nature. So the strategic planning for our end is trying to set something up early morning or late evening.
Michael, there's a few questions from Helene and from Enza with regards to notifying the membership should an employee or a resident test positive. Can you discuss and talk a little bit about what obligations, if any, a board and association may have if an employee or a resident does test positive and notify the association?
Absolutely. I would say my opinion is once the board becomes aware of a positive result in the community, they need to be notifying the membership of that positive result. You should not in any way, shape, or form inform who the individual is. And if it's a resident, and you shouldn't say what unit they're from, what floor they live on. If it's a multiple building community, it'd be okay, I think, to say we had a positive test in building 21. But I wouldn't go any more specific than that, unless the individual who has tested positive puts specifically in writing they're okay with you giving their name out. It should not be given out. And let me clarify that. Say you have a husband and wife, and the wife tests positive, and the husband says, yeah, my wife's positive, go ahead and share her name. I wouldn't do it. Unless you get the permission of the wife who tested positive, I wouldn't use her name. But you absolutely should put out a notice, and we've helped our clients put together, a form notice that they could use. But you should absolutely notify the membership, because quite frankly, if the board, it's going to come out at some point. And the last thing board or management needs is someone saying, hey, wait a minute, you knew they were positive and you didn't tell us, you kept it to yourself. That's a problem. And it's really an opportunity to remind everybody, hey, we, the board, we management are doing everything we can to kind of minimize the exposure to the community, but everybody here has to do their same job of helping out and doing that. So that type of notice, letting somebody know, hey, they're positive, and hopefully the individual is positive either is not in the community any longer, like they are staying somewhere else, or they've agreed to quarantine themselves, and that's what we expect and hope and expect. And that going forward, everybody take care. Take care of yourselves, be smart, do all the things the CDC requests, follow the rules that have been established by the boards along with them in conjunction with their management team, and work together to keep the virus spread low or nil. But yes, notify the membership, just not with specifics.
No, and just to piggyback on that, and just from a management perspective, what we're recommending our clients is just keep HIPAA regulations in mind, which is the Health Insurance Portability and Accountability Act, with regards to confidentiality and so forth. So I couldn't agree more with Michael. It is a question that's coming up quite a bit. And if you have further questions on that, you should consult with your legal counsel. A lot of pressure from residents with regards to season coming up and people coming into South Florida and wanting to have their amenities open. This is a question from Marianne. That board members are under a lot of pressure. What advice, Michael, would you give board members, again, going back to opening up any additional amenities that haven't actually been opened yet?
Yeah, I mean, right. Obviously, as the state and in particular the Tri-County area is moving to phase 2, there is I would say, a level of increased pressure, perhaps, on boards to be opening or reopening or further expanding the opening of amenities. And with respect to those who feel that way, I think it's a situation that each board, along with their management team and their other professionals, needs to consider on a case-by-case basis. As I mentioned, the orders remain in place. So let's use the pool. Pool's the easiest example. Well, pool as an example. There are requirements in place with opening up your pools. There are still limitations on the number on capacity. There's in Palm Beach, there's monitoring requirements. In Broward, if you're keeping furniture out there versus not keeping furniture out there, there's additional requirements. Miami-Dade has these requirements, and the ability to monitor and enforce the order requirements with regard to pool opening remains the obligation of the association. And so if you don't believe you have the resources and the ability to maintain the requirements that these orders put in place, then you're not ready to open. I mean, the Broward County order, by example, they actually put in their order, and I'm paraphrasing, but they basically said, here's what you need to do to open. If you don't believe you have the ability to do this, you do not need to open. And I greatly paraphrase it. That's a simplified version of what they said, but essentially that's what they said, and that applies everywhere. That said, you definitely, you have the ability to, if you can, open, then what you're determining this as a business decisions. These are business decisions the board make. You have business judgment, reasonable business judgment, and you have to determine, okay, what can we handle, what can't we handle? And that's something, again, if you're working with management, you absolutely want to be sitting down with your management team and you want to be discussing with them what can we handle, what can't we handle, or how can we do this? And I know that people are wanting to try to offer and open more. And so in that regard, I say that another thing I've said is, if you have the ability to start opening or reopening a little further, then by all means try to do so with your limitations in mind, and reminding everyone we're doing this under these these restrictions. If you don't follow these restrictions, it's going to be on you that we are closing up again. Don't shoot the messengers kind of thing. The board members are trying to do what we feel is best for the association. And bottom line is, owners need to recognize board members are owners also. And they probably want to use the pool and other amenities. But what they have to do is they have to take their owner hat, turn it sideways, their director hat put is on, and they have that enhanced fiduciary duty. They have to be saying, it's not what I want, it's what I believe is best for the community as a whole. And that's how hopefully those jive. They don't always do that. And so board members have difficult decisions to make during this pandemic again. And so I ask everyone just to have patience, cooperate, and recognize the difficult challenges that board and management are facing.
We have some really great questions coming from the attendees here in the webinar. I'll start with Ira. And this is probably geared towards Michael as well as Joe and John. Association stipulating their reserve schedule for insurance deductibles and hurricanes since there's no useful life. Is there any type of case law or any type of statute that affords an association the ability to reserve for those types of claims?
I guess that's probably more to me. Ira, that's an excellent question. In my opinion, and the way you phrase it, Ira, is exactly on point. Reserves, at least, and let's also recognize there's condominium statutory reserves, and then you have the HOA, and I believe we're probably more talking condo here, but do understand if you're in an HOA, reserves are only considered, quote, statutory reserves if the developer had included them in an original budget before turnover, or if the membership at any time voted for reserves, which in my experience is very unlikely. So in an HOA setting, reserves, if they're not statutory, are more contingency, if you will, where you could earmark them for something, but they're not limited to that if the board determines there's another proper business purpose to use them. In a condominium setting, you do have statutory reserves. And to Ira's point, I don't believe a statutory reserve would include the insurance deductible. The statutory reserves are for your paving, your painting, your roof, and any other capital improvement of excess of $10,000. A reserve fund for an insurance deductible doesn't come under that definition, in my opinion. So I don't believe it would be considered a statutory reserve. I believe the board could create a line item and put money aside, earmark it for that. But I think it likely comes under the same example I gave with the HOAs, that it's more of a line item that we want to use, but if for some reason we need it for another purpose, we're going to be able to take it for that purpose. That's something that is something I haven't fleshed out. I haven't discussed that. It's not an issue that's come up that anyone's ever challenged. Hey, you created a reserve for deductibles and now you're using it for, a maintenance item. I haven't had that issue come up. I believe, though, that the board would have the discretion to use it if they needed it. Joe, do you have anything more?
Yeah, you said it. The easiest way to do it is to have a line item on the budget for insurance deductibles.
Under your operating expenses.
Exactly.
I hope that answers your question. The next question I want to go to is geared towards JP. JP, you mentioned some of the disinfecting chemicals that your team and Super Restoration is using. How long does the disinfecting you provide last? And should it be weekly, bi-weekly, or daily?
Excellent question, Dave. So basically it lasts as long as until somebody comes around and tests positive and touches the surface, so on and so forth, right? Now, when I say clean, disinfect, and protect, there's also a product that's called Armor that we're advising boards, condo managers to use when we're doing this cleaning process. And what it is, it's a masking agent that primarily can last from 1 day up to 6 months because there's no paper trail behind this, okay? But this product, they're using it on cruise ships now, and it's supposed to be a masking agent to really protect on any surface for viruses to grow. That helps eliminate one expense in the sense of to keep re-cleaning from a frequency perspective, right? I have buildings that are hiring us to do this twice a month. Some of them wanted to do 3 times a month. Sometimes they're doing it once a month, right? It depends how proactive they want to be and what type of budget they have. But is there any 100% guarantee as soon as we walk out of that building that they're not going to have a problem? Absolutely not. And anybody that tells you otherwise, please be careful. And that's per the CDC.
Thank you, JP. I just want to address some of the other questions that were coming in. A lot of people are asking about the insurance rates and where should I budget for my building? How do we know what to guesstimate? It's going to depend on exactly what your building characteristics are, your loss history, where your building is located, if you're on a barrier island, the year of your roof, and the opening protection. And I'm going to put this question more over to Joe, and he can expand on it. On one, we don't know exactly where the insurance rates are going. We know that they're going up, but it's going to depend on a case-by-case basis. And you can get with us and we can kind of help project better budget indications for you. I'm going to turn this over to Joe on how we can mitigate the rising insurance rates that we're seeing in this marketplace currently.
Thanks, John. Very good questions. A hot topic lately on a lot of levels. First of all, it's really important that you meet with your broker pre-renewal time, 4 or 5 months ahead of the renewal. Sit down, go over any updates that are done to the building, any improvements. Some of the key things are the age of the roof, the last time you were re-roofed. If you went from not having 100% opening protection or impact glass to going to 100%, if your building that has had a lot of leaks and had to call JP a lot, did you install a leak detection system? These are all key underwriting things that help mitigate rising costs. Also, more important than ever is that you have a current appraisal. As the marketplace shrinks in choices, as we go in this hard market, many of the carriers are requiring an updated appraisal. An updated appraisal is considered an appraisal under 3 years old, and that's a statutory requirement. I do want to mention that we've had a trend of the appraised values the last few years going up with increased costs of construction and labor. But because, it's kind of interesting, because of oil prices going down, the last few appraisals we've seen are either flat or coming down a little bit. So it's real important more than ever to update your appraisals. Also, when you sit down with your agent and you go over the renewal and you're projecting budgets, look at what hurricane deductible you have. Over my experience in hurricane deductibles, they've been 2, 3, 5%. The 2% or even 1% came in the soft market. Maybe it makes sense that you go back to a 3 or a 5 and you buy glass coverage. There's all kinds of ways to mitigate these increases.
That's great. Thanks, Joe. Going towards reopening protocols as well, another question that continues to keep coming up. And by the way, we have some great questions coming in through the live chat. So please, if you have questions that are specific to your community or questions that may have not been answered up until this point, we encourage you to use the live chat and we will get to that question as soon as possible. Can a property continue to restrict the building to residents only, Michael?
It could restrict to residents only. I don't, that's the answer is maybe. It's like, I guess I'd want, if there's a particular building that wants to restrict to residents only, I'd want to speak to them about more specifically what their questions or concerns are. The state of emergency remains in play. As a result, the emergency powers that are under 718, 1920, in my opinion, and the opinion of many practitioners in the state, also remain in play, giving the board certain discretion, certain authority. But those emergency powers are not just boom, you can do whatever you want. There has to be a reasonable connection, a nexus between what it is you are using that power for and why you're using it. So obviously, as the orders that when it started, we had state order, we had county order, we even had municipal orders that had very strict. And a board, an association, cannot be less restrictive than those orders. So you had no choice but to, at a minimum, follow those orders. You can be more restrictive. Which, to the listener's question, yes, a board can continue to be more restrictive. The fact that like a fitness center, a public fitness center is open up the road doesn't mean that the association has to open up their fitness center if they don't believe they can open it up safely. But whether or not they can open it up safely becomes a question of fact. And it goes back to what I spoke earlier about a board business decision and communicating with your management team and getting with your legal counsel as to what is your position to support why we are limiting it to residents only. There may be very good reasons that are supportable, but before I couldn't give you a yes or no to that. I'd say, and that's why I'm not a fan of maybes. Obviously, that's not how we give legal advice. And this isn't legal advice, but bottom line is you need to know the facts of the situation. You need to be able to best support why you would continue to limit it to residents only.
Well, that's totally fair, and I would just piggyback that is for any board members in attendance, when in doubt, speak with your professionals.
Absolutely. I mean, it's a tough, like I said, it's a tough situation. It's a first impression. Your management team's got, experience of multiple communities. Your attorneys have the experience of multiple communities and your insurance team as well. Obviously JP and his guys know what they're doing with the cleaning, and so you should be getting them in as much as possible.
That's fair. And I have another question that's geared towards Joe and John, and it may be as simple as an answer as we can't discuss it. But, we're talking a lot about what types of coverages associations can purchase to make sure that they have proper coverage in the event that a claim is filed. Have you come across any claims to this point, either in condominium or homeowners associations, that you can speak to?
You're talking about COVID?
Yes.
Yeah, we've had a couple that we've leaned on our prepaid legal product for. Yep, like 2 so far. I can answer that.
We just can't discuss details, but we can definitely say there has been.
But, to that point, even more so, and just from a personal opinion standpoint, again, not giving any specific advice or legal advice, is, the longer this goes on, and as it starts, hopefully a vaccine comes out and this starts to be behind us, we may, and we very well may, see a lot more claims coming about from it. So speaking with your insurance agent regarding those coverages that Joe and John spoke so in depth about is even more important.
Yeah, and David, just on that point, I was actually appointed to a task force. They called it Reset, R-E-S-E, Reset. The governor put together a task force where I was as the chair of the legislative alliance. I stepped on as a business task force of businesses. So our community associations, as we all know, are businesses. And I was on this task force representing us as community associations. And the purpose of this is to propose legislation that will address liability exposure and the limiting of liability exposure. So we put together some proposed legislation. Unfortunately, Tallahassee, they weren't meeting again. They didn't have a special session or plan to have a special session this year to consider it. So, and it's going to come up in session next March. and whether, if it passes or how it passes, and whether it would apply to limit this exposure. But that would go, I think, a long way toward giving board members and even management teams a clearer view of what legal liability exposures there are, and certainly help your insurance agents and your insurance team to be able to better guide you on coverages when we understand the level of liability exposure. So these have passed around the country. These types of limited liability bills have been passing around the country in different forms. Some are horrible, in my opinion. Some are very good. We put together what we think is the best, middle ground, and we'll see what happens. But that's also been something actively this summer we've been working on.
We're coming up towards the conclusion of the webinar, so at this point in time, I want to encourage all the attendees, if you have any final questions, to please submit them through the Q&A so that we can get to them prior to concluding the webinar. Mary Ann asked the question, will an environmental insurance policy offer any protection against COVID?
No. There's a specific exclusion on, they're also called pollution liability policies for infectious diseases. And the ones that didn't have the exclusion, they're actually endorsing the policies to exclude COVID-19. So to make it clear, I haven't seen one that'll cover it.
Real quick, Joe, I just want to jump on this real quick and jump on this question and piggyback on this.
Sure.
We've seen a lot of exclusions with different parts of policies. Let's just reference mold for a minute, right? And we're seeing more carriers now. If you do any contingency planning trainings that management took or the staff took, they're starting to let them have certain coverages, right? They're going from an exclusion to allowing the coverage.
Mold, yes.
Do you see that in the foreseeable future with COVID potentially?
Who knows? Amwins came out with a product for COVID, okay? And of course, Brown & Brown, you have to pass our QC department for us to offer it. And it has to be an entire statewide shutdown in order for it to pay, and it's crazy expensive. So the marketplace is in a flux right now. Things are gonna come out, things are gonna be offered because it's that new. But stay tuned. But right now, make sure you have a prepaid legal policy. It'd be crazy if you didn't.
Joe, if a client asks you what the best insurance policy or coverage is out there to cover claims against COVID, is there a specific carrier that you're recommending?
There are only 2 or 3 programs right now. Bold is the product that we mostly use. We've had some traction with them for a few years, and we've had some success stories with other types of claims that are denied. This prepaid Bold, by the way, jumps in and gives you unlimited defense costs with no deductible for any claim that is denied by a carrier for any reason. It's not just COVID.
Right.
So we've been using it for several years now.
David, if I may, Scott just put up a question that I think needs to be answered. If I may. Okay, so Scott, you said the emergency order no longer applies to COVID as of June. Respectfully, that is a misconception. What that I believe, Scott, you're referencing is the Halsey Brashears, the Secretary of the DBPR, issued an order effective June 1st, rescinding an order that he made in March that stated, hey, the state of emergency kicks the, and I'm paraphrasing, of course, kicks the emergency powers in 718 into play. He also addressed 720, which quite frankly, the DBPR doesn't have jurisdiction over, so that's a separate issue. But respectfully to Secretary Brashears, I don't believe his order, when I say I think this is a very, very overwhelming majority of practitioners in this area in the state, not everybody, but overwhelming believe his order wasn't necessary. The issue of confusion is that in these statutes, the emergency powers kicked in if there was an issue of damage occurring. And while those emergency powers were created in response to the hurricanes that we had in 04 and 05, the damage that the COVID pandemic has created, I believe, and I think most believe, would cover and kick in those emergency powers. So his order in March, while appreciated, wasn't necessary. His rescinding of that order effective June 1st caused a level of confusion that, Scott, you're not the only one who have had to bring that up. So respectfully, they did not end in June. As long as the state of emergency is still in force and it has been extended by the governor till November 3rd, Those emergency powers in the statutes do remain in play, but like I said, they have to be utilized in connection with what it is you're using them for. Simple example, you don't have the ability to have board decisions without having board meetings. The emergency powers do not let the board go ahead and just make decisions because, hey, this is a state of emergency. You still need to properly notice your meetings. You still need to allow members to attend. You allow members to speak. How you notice it is as much as practicable. That's what the emergency powers, but you don't have the ability to just make decisions and ignore having meetings. But those emergency powers absolutely remain in force, in my opinion, and I think the opinion of most. I hope that clarifies.
We have a question from Andrea. Michael, are you aware of any legislation either before the state or the Senate with regards to case law or potential claims from residents and profiting from frivolous lawsuits against an association?
Andrea, I am not aware of anything specific addressing that. I mean, I probably would want to get more details from you on what you're talking about, and so you're welcome to send me an email, mbender@kbrlegal.com, to talk to me about that, because actually Saturday is our first session, our CAI's FLABA Legislative Alliance. We're having a session Saturday, Zoom in person, to set our legislative agenda for 2021. And so I'm not quite sure what that means, but again, I encourage people to kind of present ideas, and we'll do what we can to run with them or let you know why they won't work.
Excellent. At this point in time, we're approaching the hour mark, and I believe we have answered all the questions in the chat. If there's anything else from the panelists, I welcome it at this time. Otherwise, this is being recorded, and for anybody who would like to view it again or share it with their colleagues or board colleagues, we'll have that ability from our websites and email distributions.
David, we thank you and AKAM for organizing this. Thanks, everybody.
Yes.
Oh, it was our pleasure. And again, on behalf of AKAM, thank you so much to all those attendees that joined us this afternoon, as well as Michael Bender from Kaye Bender Rembaum, Joe Knapp, and John Moeller from Brown & Brown, and of course, JP from Super Restoration. Thank you so much.